Robert Mitchell was 72 years old when he made the biggest mistake of his life.
He owned his home outright, $425,000, paid off over 30 years, 5 grandchildren. He thought he was protecting his family's future, so when his children sat him down at the kitchen table and suggested he sign the house over to them to avoid probate, to keep it in the family, to make things easier when the time comes, Robert trusted them.
30 days later, Robert was living in a state-run nursing home. His house sold for $425,000. His kids, they divided the money 3 ways and stopped returning his calls. I'm the Vault Files, and this investigation will show you exactly what happened to Robert and the 8 critical protections every elderly parent needs before transferring any property. Because if you don't watch this to the end, this could be your parent's story. Let's unlock the vault.
Robert Mitchell, 72 years old, retired postal worker, widower for 3 years after his wife Linda passed from cancer. He lived in the same house in suburban Phoenix that he and Linda bought in 1994. 3 bedrooms, 2 baths. Nothing fancy, but it was theirs. By 2023, the mortgage was paid off. The house was worth $425,000. Robert's only income was his Social Security, $1,200 a month, and a small postal pension of $800, $2,000 a month total. Not rich, but comfortable, and he owned his home free and clear. Robert had 3 children. Mark, the oldest, worked in real estate. Jennifer, the middle child, was a stay-at-home mom with 2 kids, and David, the youngest, was between jobs. Here's what you need to understand. Robert was in perfect health, sharper at mind, independent. He did his own grocery shopping, paid his own bills. This wasn't about incapacity, this was about opportunity. In April 2024, Mark called a family meeting. He told Robert they needed to discuss estate planning. The 3 kids sat Robert down at his own kitchen table. Mark did most of the talking. He'd been doing some research.
Mark explained that when Robert eventually passed away, the house would have to go through probate.
Probate is expensive, he said. It takes months, sometimes years. There are attorney fees, court costs. It's a nightmare. But there's a simple solution, Mark said.
Sign the house over to the 3 of them now. They'd own it together. Robert could live there for the rest of his life. When the time came, there'd be no probate. The house would already be theirs. Jennifer chimed in.
We just want to protect the house, Dad.
We don't want to lose it to nursing home costs or taxes and like that. This is what everyone does now, Pop.
Robert hesitated. Something felt off, but these were his children. They'd never steered him wrong before. Mark sweetened the deal. Dad, you'll always have a place here. This will always be your home. We're just making sure the government can't take it.
Mark pulled out a quitclaim deed he'd already had prepared. No attorney present, no independent counsel for Robert. Just a 1-page form that would transfer Robert's $425,000 asset to his 3 children for $0.
Robert signed.
For the first 2 weeks, nothing changed. Robert lived his house. His kids called once or twice to check in. Everything seemed normal. Then Mark called. Hey Dad, we've been talking. Jennifer's house is pretty cramped with the kids, and we were thinking, what if you moved in with her for a while? You'd get to spend more time with the grandkids.
Robert said no. He liked his house, his independence, his routine.
Mark called again 3 days later. This time, his tone was different. Dad, we've been looking at your finances. You're spending too much keeping up this big house. The property taxes alone are killing you. We found a really nice senior community. It's assisted living, but it's got activities, meals included. It's actually a great deal. Robert said absolutely not. He didn't need assisted living. He was fine. Jennifer called next. Dad,
we're worried about you.
You're alone in that big house. What if something happens? What if you fall and no one finds you for days?
I'm fine!
Then David called. Pop, I hate to bring this up, but we're the ones on the deed now. We're liable if something happens to you in that house. What if you fall and sue us? We could lose everything. And that's when Robert understood. His house wasn't his house anymore. Legally, his children owned it. And legally, they could do whatever they wanted with it. 28 days after Robert signed the deed, Mark showed up with a moving truck. Robert's belongings, 60 years of life, were packed into a 10x10 storage unit that the kids paid for 6 months in advance.
Robert was driven to a Medicaid-funded state nursing facility.
Not the nice assisted living they described, the state nursing home. Because Robert's income was too low to afford private care, and because he no longer owned any assets. Within 90 days, his house was listed for sale. It sold for $425,000. After closing costs, the 3 kids split $398,000, $132,666 each.
Robert tried calling his children. Mark sent texts saying they were dealing with legal stuff and would call back soon. Jennifer stopped answering. David blocked his number.
The grandkids? They were told Grandpa needed special care and visits would be too upsetting for them.
Robert Mitchell died in that nursing home 14 months later. He never saw his house again.
Now, before we go further, I need you to understand something. Robert's story is not unique. According to the National Center on Elder Abuse, financial exploitation happens to 1 in 10 Americans over the age of 60. And the perpetrators? 75% of the time, it's family members.
But here what makes property transfer cases particularly devastating: the parents consent to it. They sign the papers willingly, which means legally it's incredibly hard to undo. So why do elderly parents agree to this? Because their children, or sometimes unscrupulous advisors, feed them for specific myths. Myth number 1, you need to avoid probate. Here's the truth about probate. Yes, it costs money, typically 3 to 5% of the estate value. For a $400,000 house, that's $12,000 to $20,000. Sounds like a lot, right? But transferring the house to your kids can cost you way more. Capital gains taxes alone, which we'll get to in a minute, can exceed $100,000. Plus, probate is a protection. It's supervised by a court. It prevents exactly the kind of theft that happened to Robert. When there's no probate, there's no oversight. Your kids can do whatever they want, and there's no judge looking over their shoulder to make sure they're following your wishes. Myth number 2, you need to protect it from nursing homes. The logic goes like this. If you ever need Medicaid to pay for nursing home care, Medicaid will take your house to repay them. So transfer it now before you need care. Here's the problem. Medicaid has what's called a 5-year look-back period. If you transfer any asset for less than fair market value within 5 years of applying for Medicaid, you're hit with a penalty period where Medicaid cover you. For a $400,000 house, that penalty period could be 3 years of no Medicaid coverage. So not only does the transfer not protect you, it actively harms you. Myth number 3, keep it in the family. The phrase keep it in the family sounds warm and fuzzy, but here's what it actually means. You give up all legal rights to your property, and you hope your kids don't betray you. Statistically, 20% of deed transfers to children result in the parent being removed from the property within 2 years. 20%. That's 1 in 5. Myth number 4, you'll save on taxes. This is the most financially devastating myth of all. When you die and your kids inherit your house, they get what's called a stepped-up basis. That means they inherit it at the current market value, and if they sell it immediately, there's zero capital gains tax. But when you transfer your house to your kids while you're alive, they inherit your original cost basis. Let's use Robert's house as an example. Robert bought it in 1994 for $100,000. It's now worth $425,000. That's $325,000 in appreciation. If Robert had died and the kids inherited it, stepped-up basis. They sell for $425,000, they pay zero in capital gains. But because Robert transferred it while alive, the kids have Robert's original $100,000 basis. They sell for $425,000, they owe capital gains tax on $325,000 at 15 to 20% federal rate, plus state taxes. That's $65,000 in unnecessary taxes. 4 myths, 4 lies that elderly parents are told every single day. And these lies don't just cost money, they destroy lives. Let's talk about what actually happens after an elderly parent transfers their home to their children. Disaster number 1, total loss of control. The second that deed is recorded, the parent owns nothing. They're not a co-owner, they're not a tenant, they have zero legal rights to the property. The kids can sell it, rent it out, take out a mortgage against it, evict the parent, all without the parent's permission. I found a case in Florida where an 80-year-old woman transferred her condo to her daughter. 6 months later, the daughter sold it to pay for her own divorce attorney. The mother became homeless. Disaster number 2, the Medicaid penalty. Remember that 5-year look back we talked about? If the parent needs nursing home care anytime in the 5 years after the transfer, Medicaid will calculate a penalty period based on the value transferred. For Robert's $425,000 house in Arizona, where the average nursing home cost is $7,000 per month, that's a penalty period of 5 years. Disaster number 3, the capital gains tax bomb. We covered this already, but it's worth repeating because people don't believe the numbers until they see them. A study by the Journal of Financial Planning found that families who do lifetime transfers of appreciated property pay an average of $78,000 more in capital gains taxes than families who inherit the same property at death. $78,000. That's the average cost of avoiding probate. Disaster number 4, creditor exposure. Once the house is in the kids' names, it's now subject to their financial problems. Kid gets divorced. House is a marital asset in the divorce. Kid gets sued by a business partner. House can be seized to satisfy the judgment. Kid files for bankruptcy. House is part of the bankruptcy estate. I researched a case in Ohio where an elderly man transferred his house to his son. The son was in a car accident, got sued, lost the case. The man's house, where he'd lived for 40 years, was sold at a sheriff's auction to pay the judgment. The father never even knew his son had been sued until the eviction notice came. Disaster number 5, IRS LIENS. This is the one nobody sees coming. Remember Robert's son Mark. Let's say Mark owes back taxes, $15,000. The IRS files a lien against everything Mark owns, including his 1/3 ownership in Robert's house. Now when the kids try to sell the house, the title company finds the IRS lien. The sale can't close until the lien is paid. I found a case in Texas where this exact scenario delayed a house sale by 11 months. The IRS lien was for $87,000. The family had to negotiate a payment plan and pay off the lien before they could sell. All because Dad transferred the house to save on probate costs. Disaster number 6, Family conflict. Let's say you have 3 kids like Robert did. You transfer the house to all 3 1/3 each. Everything's fine until one kid wants to sell and the others don't. Or one kid wants to move into the house. Or one kid needs money and wants to force a sale. This triggers what's called a partition action, a lawsuit where one co-owner forces the sale of property. It costs $20,000 to $50,000 in legal fees. Disaster number 7, elder abuse and undue influence. Here's the legal standard. If a person is pressured into making a financial decision that benefits someone else, and that person is in a position of power or trust, it can be considered undue influence. The problem: it's almost impossible to prove after the fact. Robert willingly signed the deed. His kids will say he understood what he was doing. There's no legal recourse unless you can prove. The parent had diminished capacity, the kids actively coerced or deceived them, and the parent wouldn't have made this decision on their own. That's a nearly impossible legal standard to meet. Which is why 75% of elder financial abuse cases are never successfully prosecuted. 75%. 3 out of 4 victims get no legal justice. Disaster number 8, no path back. This is the most devastating reality of all. Once the deed is transferred, it cannot be reversed without the kids' cooperation. If they refuse to transfer it back, and why would they? They now own a $400,000 asset. There's nothing the parent can do. The kids own it, legally, completely. The parent gave away the keys to their own home, and now they're locked out forever. 8 disasters. 8 ways that a simple estate planning move destroys an elderly person's financial security and independence. But here, what makes me the angriest about Robert's story and the thousands like it, all of this is preventable. If you have an elderly parent, or if you are an elderly parent, and someone is suggesting you transfer property, here are the 8 steps that could save everything. Step 1, never transfer outright. Never ever sign a quitclaim deed or warranty deed transferring property directly to your children. There is no scenario where this makes sense. Not for probate avoidance, not for Medicaid planning, not for tax savings, not for anything. If someone tells you this is a good idea, they're either ignorant or they're scamming you. Step 2, use a trust instead. If you want to avoid probate, which is a legitimate goal, use a revocable living trust. You transfer the house into the trust. You are the trustee, which means you control it completely. When you die, your successor trustee distributes it according to your wishes. No probate, benefits, you maintain complete control, avoids probate. Kids still get stepped-up basis for tax savings, protected from your kids' creditors. You can change your mind at any time. Step 3, IF Medicaid planning, use an irrevocable trust. If you're specifically trying to protect assets from nursing home costs, there is a legal way to do it. It's called a Medicaid Asset Protection Trust, or MAPT. You transfer the house into an irrevocable trust. You can still live there, but you no longer own it, so it doesn't count for Medicaid. The catch: you still have to survive the 5-year look back. But if you do this in your 60s or early 70s, by the time you need care in your 80s, you're past the look back. Step 4, if you absolutely must transfer, retain a life estate. Step 5, use a professional trustee, not your kids. Banks and trust companies have fiduciary liability. Step 6, family meeting with attorney present, your attorney, not your kid's attorney. Make sure everyone hears the same information at the same time. Step 7, limited power of attorney with restrictions, specifically prohibit your agent from transferring property to themselves. Step 8, annual third-party audit by independent accountant, $500 to $1,000 per year. Compare that to the $400,000 Robert lost. It's the best insurance you can buy. These 8 steps won't just protect your property. They'll protect your independence, your dignity, and your relationship with your children. Because here's the truth. Good kids who have your best interests at heart will not object to any of these protections. Only kids who are planning to take advantage of you will push back. What if you're watching this and thinking, oh no, this already happened to my parent or to me? Here, what you do right now. 1. Document everything: texts, emails, recordings, witnesses. 2. Call Adult Protective Services immediately. 3. Contact an elder law attorney who specializes in undue influence claims. 4. File an undue influence claim if your parent has dementia or was pressured. 5. Appeal Medicaid penalties on grounds of elder abuse. 6. Get help, elder care locator. Robert Mitchell's story ended in a state nursing facility, alone. His life savings stolen by the people he trusted most. But your parent's story doesn't have to end that way.